Mr. Speaker, given the magnitude of the matter that was before us, he could have asked for an email from that particular hospital confirming what was happening. Therefore, to wrongly accuse this House, Mr. Speaker, that we denied Deputy President Rigathi Gachagua an opportunity for fair trial, Mr. Speaker, I felt, Mr. Speaker, that that should not go without challenge. I am happy that you have put it on record, Mr. Speaker, that as a Senate of this Republic, we shall be challenging that finding because we completely disagree with it. We did our work, Mr. Speaker, with utmost good faith, Mr. Speaker. Lastly, on this particular item of fair trial, Mr. Speaker, and maybe I could say this, listening to the judges yesterday, Mr. Speaker, as I have always argued on many occasions, that there is a clear struggle by members of our bench in this country, Mr. Speaker, to understand the procedures of this House. Either they humble themselves and invite an invitation, Mr. Speaker, for a sort of understanding between us as a legislature and them as a judiciary, so that they better understand our procedures, Mr. Speaker, as opposed to them trying to invent and guide us on how we do some of these procedures. I listened actually with utmost shock. One of the judges argued, Mr. Speaker, that it was faulty for us to elect to trial an impeachment by way of committee of the whole, that we are only supposed to do it by a 10-man committee. I could not believe it, Mr. Speaker, that is a judge of the High Court of the Republic. It is my hope, Mr. Speaker, that these obvious errors which I see judges continue to make on the work of Parliament, Mr. Speaker, that between you as a Speaker and the Chief Justice, that one day you shall organize a colloquium where we can educate each other on procedures of both houses, as opposed to one party appearing to guide the other on procedures of the other arm of government and doing it so wrongly. Therefore, Mr. Speaker, in conclusion, while I celebrate this, Mr. Speaker, I want to agree that we must enter, Mr. Speaker, a notice of appeal in the quickest time possible, because this cannot remain unchallenged. We did our work in utmost good faith, Mr. Speaker, and McHugh, appearance by speaking was not the only way of trial that we could have done on this matter. Remember, there were already affidavits that were before us, sworn by the same individual, Mr. Speaker, informing us of his responses to all the matters that were before us. Therefore, listening to him was just to confirm what his affidavits were telling us. Therefore, it is not fair to say that we never granted him an opportunity to be heard by this House. I thank you, Mr. Speaker, and I agree with that decision. Thank you so much.
Senator Mazayo.
Asante mstahiki Spika. Mstahiki Spika, kwanza nataka kusema ni jambo la kusikitisha kuona ya kwamba katika uamuzi wa wale majaji walioketi watatu waliweza kuona ya kwamba pengine Senate haikumpatia nafasi ya kuweza kujitetea vilivyo kama mshtakiwa. Lakini nataka kusema ya kwamba runinga na kila mahali waliona katika Kenya nzima ya kwamba katika kesi hii tulimpatia nafasi yule aliyekuwa ameshtakiwa, Bwana Gachagua, Mheshimiwa Gachagua, kwa nyakati zote. Hata tukizingatia zaidi ni kwamba ulikuwa wakati mwingi tulimpatia wa asubuhi yote mpaka wakati wa karibu saa 7. Aliongea zaidi ya masaa 6 akiweza kuulizwa maswali ambayo anaongozwa na wakili wake, na wakili si mwingine bali ni wakili maarufu sana, na ni wakili ambaye amebobea katika sheria, ndugu yetu awasinia ambaye ni Paul Mwite aliweza kumpeleka kulinganisha na vile alivyokuwa ameandika taarifa yake, akaileta hapa, na yale yote hiyo ilikuwa katika record. Na jambo la kusikitisha zaidi ni kwamba baada ya kwamba mawakili wote wale waliokuwa nao walipewa nafasi pia kuongezea kuzidi kumweka vizuri Bwana Gachagua, na alikuwa yuko sawa kabisa. Asubuhi wote alikuwa yuko sawa, alikuwa anacheka na anajibu maswali kisawa sawa. Bwana Spika, baada ya hapo sasa, kwa sababu ilikuwa katika sheria zetu tunasema ya kwamba ikiwa tutakusikiza wewe kama bunge lote, yani a committee of the whole house, ikiwa tutaketi chini na kuweza kusikiza, basi kila mtu atawahi kuuliza maswali. Na ilikuwa amemaliza asubuhi yote mpaka saa 7, akapatia watu kama dakika 30 40 kwenda kupumzika tu, ambalo ni jambo la kushangaza, kwa sababu wakati watu wamepewa nafasi ya kwenda kupumzika pengine kwa lisali moja, ingekuwa na akaondoka na wakili wake kwenda kujadiliana. Tunatarajia mchana ukifika, pengine wale maseneta watakuuliza swali hili na hili na hili na hili, wakamtayarisha ili aje. Lakini jambo la kusikitisha ni kwamba walipokwenda huko, dalili zinaonyesha wazi kabisa ni kwamba walimwambia wewe usijaribu kurudi tena, kwa sababu lile bunge la Senate inaonekana wako tayari kukuuliza maswali. Na ni vile vile kumalizia ni kwamba si usawa kusema ya kwamba utarudi mchana, ama umeagizwa na bunge la Senate, umeagizwa na speaker kwamba njoo mchana sasa utapata nafasi ya kuweza kujibu maswali utakayoulizwa na maseneta, kwa sababu sasa ni wakati wa ile nyumba ya Senate yote kuweza kukuuliza maswali. Bwana Spika, hapo mimi naona ni jambo la kusikitisha kusema kwamba katika wale majaji waliokuwa wameketi pale kwamba hakupewa nafasi ya kujitetea na bunge la Senate. Hapo naona kidogo kulikuwa na mushkili wa hiyo uamuzi wao. Kwa hiyo ni umuhimu ikiwa bunge la Senate linaweza kuchukua hatua hiyo kuweza kujitetea vilivyo, tukipewa nafasi watakapokuwa wameenda katika hiyo koti wanaosema, ama wakienda katika koti yote. Lakini koti ya rufaa ya kitengo cha juu ni kwamba bunge la Senate lazima lijitetee. Hakukuwa na uagizo wa kwamba alikuwa ameomba apewe ridhaa ya milioni 50. Kwa hiyo hatuoni hata kwa nini wanaweza kuchaji, ama ilikuwa vipi mpaka wakafika hiyo milioni 50 ya kwamba Senate iweze kulipa katika hiyo kesi iliyokuwa ndani ya koti. Kwa hiyo sisi tunasema hiyo kesi tuko na nafasi nzuri kama bunge la Senate kuweza kujitetea, na hata wananchi wenyewe waliona wazi kabisa kwamba bunge la Senate halikupewa nafasi ya kumuuliza maswali, kwa sababu yeye mwenyewe hakuweko wakati wa mchana. Iliibuka tu baadaye kwamba alikuwa ameenda katika hospitali inayoitwa Karen, na halafu baadaye, baada ya miaka 2, daktari wake anaandika ile tunaita affidavit ama maono ya haki, akisema kwamba pengine alikuwa ni mgonjwa. Lakini sisi hatukuletewa karatasi yoyote ya kuambiwa kwamba yeye ni mgonjwa. Kwa hiyo kama Senate haikuambiwa yeye ni mgonjwa, itakuwaje Senate iweze kupigwa fine? Kwa hiyo bwana Spika, mimi naona uamuzi uliotolewa na hiyo koti ya hao majaji watatu ulikuwa si wa haki, na inafaa utupiliwe mbali katika koti ya juu zaidi. Asante bwana Spika.
Now, honorable senators, this was just a communication, not a source of debate. I will allow maybe 2 or more, but keep it under 3 minutes. Senator Boni.
Thank you, Mr. Speaker. Mr. Speaker, I want to speak strongly on your communication, because there is an attempt in this country for certain people, irrespective of their status in society or the offices they hold, to belittle the role of institutions. Mr. Speaker, if we allow Parliament, and Senate in particular, to be challenged in the manner that the judges did, we will be weakening Parliament, and there might be a deliberate attempt, Mr. Speaker, to ensure that the powers where we sit as a trial chamber that maybe do not please the people who practice in the courts should be removed from the institution of Parliament so that it remains there preserved. Mr. Speaker, I want to agree with you that we must appeal. But Mr. Speaker, I have heard you. I want to request that you consider also factoring in the appeal what Justice, allow me to quote, what Justice Anthony Mrima said himself, without being prompted by the Council of the Senate. Mrima said, it must be emphasized that the Senate is not a mere conveyor belt for matters originating from the National Assembly or any other entity. He went on and added that it is a revered house vested with autonomy and empowered to make decisions by way of resolution, and therefore the Senate retains the discretion to determine whether to accept any motion or petition for further deliberation. He must be reminded that when he was thinking rationally, as I have quoted him, how was he expecting this Senate without any application from Senior Counsel Paul Mwite that his client had fallen ill? How, without evidence, did he expect the Senate with the kind of discretion that he has?
1 minute to conclude.
In conclusion, without that, for us to then agree with them, are they saying if somebody facing charges of robbery with violence flashes and dashes out of court, and his lawyers say, we don't know where he is, we don't know where he's going, then the judge immediately says that we discontinue the proceedings? No, Mr. Speaker. Mr. Speaker, we have gone to school properly. The purpose of university education is for you to have organized thinking, critical thinking, the capacity, Mr. Speaker, to see the difference between right and wrong. The judges were wrong yesterday on this one. Thank you, Mr. Speaker.
Senator Kajwang.
Mr. Speaker, in many legal systems, a jury does not have to justify the decision that it has made. A jury does not have to explain itself. And so as a House, we sat as a jury. We should not try to justify the decision that we made, because the decision that we made was in line with the Constitution. Mr. Speaker, I heard some people say yesterday that yesterday was a funeral of the Republic of Kenya, the funeral of the Constitution. I want to tell them yesterday perhaps was the birthday of the Republic of Kenya and the birthday of the Constitution. Because if this matter goes to the Court of Appeal, goes all the way to the Supreme Court, it will help us address some things that have remained outstanding for long. The issue of impeachment processes, the issue of public participation, the issue of Chapter 6. Mr. Speaker, I would be happy if the Court of Appeal or even the Supreme Court could be moved at certain points in time to expand the scope, the limitation on holding of public office on account of violation of Chapter 6 to go beyond persons who have been impeached and to perhaps include persons who have been indicted by the Auditor General and other institutions like the EACC. Mr. Speaker, I fully support your decision to appeal that particular matter. And Mr. Speaker, if there was a problem in terms of raising the 50 million, that is in case you are not successful in appeal, I want to inform the House that the Public Accounts Committee has issued fines of 500,000 shillings to 20 governors. So we'll be able to raise at least 10 million shillings. But, Mr. Speaker, I do hope that we shall not get into it. But, though, Mr. Speaker, a fundamental observation that I saw yesterday in court is that members of this House who sat as jurors who participated in the process would go to court and would go to court to defend or to represent positions against the Senate. Mr. Speaker, there needs to be some hygiene. We must decide whether we want to be senators or we want to be litigants out there challenging decisions of the Senate. Mr. Speaker, once you have sat as part of the jury in this House, it would appear to be out of order for you to go out there and say that you agree with the judges, that there was no due process, there was no fairness in the Senate. That is a matter that must be dealt with. And Mr. Speaker, the Constitution is clear on state officers taking up other paid jobs. Those are things we must look at. But, Mr. Speaker, I am happy that the courts made that decision. Let's allow the Court of Appeal to deal with the remaining issues, and let's also accept that no institution is infallible. Let's accept that we can make decisions, and anyone aggrieved can go to court, and anyone aggrieved at the High Court can go to the other levels. But I hope that this then marks the...
Senator Mungatana.
Thank you, Mr. Speaker. Mr. Speaker, Paul Mwite was behind me here. I was seated very closely to him when he told us a ridiculous thing that he does not know where his client has gone. And Mr. Speaker, in the same breath, Paul Mwite was telling us he needs time. We gave him time as a Senate to go and look for his client. He came back and said he does not know where his client is. And Paul Mwite is a senior counsel, Mr. Speaker. He used to be chairman of our law society when we were younger and in active practice. So, Mr. Speaker, we found this extremely ridiculous. There is no way that we can reward misbehavior in court proceedings. We cannot reward that, Mr. Speaker. I fully support, Mr. Speaker, that we should file an appeal in proceedings, whether they are quasi-judicial or they are proper judicial. If you choose to run away from those proceedings, you forfeit your rights. You forfeit them by choice. And Mr. Speaker, the videos are all here. We must not create the impressions amongst Kenyans that Mr. Gachagua's rights were violated. There was no violation. He chose to run away. That's a fact. He ran away, didn't tell his lawyers, didn't tell anybody, and we must tell the truth as it is. He knew that he was coming for cross-examination. When he was saying his case, it was okay. But when he knew that you are going to ask about the family affairs, ask about the violations that were being complained of within the family, he knew, Mr. Speaker, and he ran away. He ran away from this court, Mr. Speaker. He ran away. He should not tell Kenyans or the court tell us that we didn't give him a chance. He simply disappeared. And the court must be fair to this Senate. This Senate gave him all the opportunities, Mr. Speaker. We must appeal these decisions, and Kenyans must be told the truth. Possibly, Mr. Speaker, these clips must be replayed on KBC or any other channel so that Kenyans can know the truth. The judges were totally wrong on this one, and they must be told on their faces. They were wrong. You cannot, even them, if an accused person runs away from your court, you don't stop proceedings. You proceed because he chose to forfeit his right.
Senator Wambo.
Thank you, Mr. Speaker. I walked in and my neighbor, the senator for Tana River, was very agitated about some allegations he's making on the floor. The Speaker, I'm here to just put the record straight. What is good for the goose is equally good for the gander. We had an opportunity, the Speaker, to process the impeachment
of the former Deputy President of the Republic of Kenya, and by a majority vote, the impeachment went through. The courts were given an opportunity to exercise their constitutional duty and mandate to look into the process that this August House and the National Assembly went through and determine whether the process was fair or not fair. The Speaker, when I listen to debate across the country today, and because we don't live in isolation, we live in a society. The courts have made a ruling. They have said, the Speaker, that the constitutional right of the former Deputy President to a fair trial was breached. The Speaker, that's where we are today. There will be opportunity for lawyers from both sides of the argument to appeal. But the Speaker, as a layman, I speak as a layman, I'm not a lawyer, and in one of the forums last night, the Speaker, I made this note, that as a layman, one who is not schooled in law, I fail to understand, I have tried to understand, I fail to understand, the Speaker, how a process that a court declares to have been flawed can produce a legitimate outcome. That is the Speaker, and I think that's going to be a matter for the Court of Appeal if this matter goes there.
Senator Wambua, maybe I assist you. Your colleagues are reacting to a communication that I've made. Are you privy to the contents of that communication? Okay, then react to the communication. We are not reacting to the entire judgment, just my communication.
Thank you, Mr. Speaker. Mr. Speaker, this is what I will say about the communication. That, yes, because the Senate was also a party to that matter, Mr. Speaker, we will also appeal the decision.
1 more minute, Honorable Senator.
We will appeal to the Court of Appeal, the Speaker, and that we should, because the right that we have. And if that appeal is upheld, then the Senate will have saved that 50 million Kenya shillings. But the Speaker, even as we do that, and allow me to say this, even as we do that, this must be a constant reminder to us that whatever it is that we do, we are not the final authority. The things that we do today, 10 years, 20 years, 30 years, they will return to us, and a judgment will be passed by other people about our own actions. The Speaker, I submit.
Senator Wambua, just do like what Senator Mtata has done, getting a copy of the communication, because clearly you are not privy to the contents of that communication. Senator Cherargei.
Thank you, Mr. Speaker, sir, and thank you for communicating on this live matter, Mr. Speaker. Mr. Speaker, yesterday we saw the judgment of the High Court, and I want to agree with the House that we do appeal, because as somebody has said, Mr. Speaker, is jury in any proceeding are not subjected to be interrogated, Mr. Speaker. 50 million is a lot for the Senate, Mr. Speaker, and we did our part. I am happy, Mr. Speaker, that, and I know we raised in our submission, that the doctrine of separation of powers must be respected at all given time, Mr. Speaker. And I saw the facts. I want to advise my colleagues, is what we call re ipsa loquita. Speaks for itself. And when I saw Lady Justice Mugambi, who taught me, Mr. Speaker, that's why I'm a serious lawyer of serious pedigree, said very well, Mr. Speaker. Mr. Speaker, said with a lot of certainty that the Senate operates on doctrine of separation of powers, Mr. Speaker, and the work we do under Article 125 on the work of the committees and the standing order, as per standing order number 78, and under Article 145 of the Constitution of the Republic of Kenya, Mr. Speaker, we did our part as a Senate. And we will not allow us to be fined. I don't agree with the entirety of the judgment of the court, High Court, Mr. Speaker. I agree on the part where they agreed with us that the Deputy President was validly impeached as the Deputy President of the Republic of Kenya, Mr. Speaker. And therefore, Mr. Speaker, even let us assume, I was shocked when the court said that Dr. Kigonyo's affidavit did not have a probative value. And then they went ahead and disregarded that. How can we operate as a house when the former impeached Deputy President ran away, literally? Does it mean we needed to stop? He knew we wanted to grill him, Mr. Speaker. He knew. He had the opportunity, Mr. Speaker, under our standing order number 78. You can either appear by person or by the advocate. Senior counsel Muite was seated here. He didn't know where his client was, Mr. Speaker. And we know members of this house, which I am privy to, went and told him, run away, because we were going to fire and grill you and impeach you, Mr. Speaker, for violating the Constitution. And I can name names, Mr. Speaker, like the acting DCP SG was the one advising him to run away, Mr. Speaker. Mr. Speaker, we must stand our ground. And the High Court, Mr. Speaker.
Senator Fernandez, you cannot impute improper motive to your colleagues. Kindly withdraw.
Mr. Speaker, I withdraw and I proceed. Mr. Speaker, that is why I'm saying we gave opportunity, Mr. Speaker. And in fact, our standing order so that Kenyans can understand. Because I saw standing order number 78. You can neither appear as a person.
Senator Wakili Sige.
Mr. Speaker, I want to most sincerely thank you for the communication that you have made this afternoon, and for a very important reason. The facts ought to be made clear, because it's a bit absurd for the judges yesterday to say on the one hand that this House is independent in terms of procedure on how it deals with matters before it. It went ahead to pronounce itself that our standing orders are also constitutional, and further confirmed that indeed we were working within certain constitutional timelines and we are in charge of our program. It does not then make sense again, Mr. Speaker, for the same judges to say that having complied with what they said, our independence, our mandate, our constitutional timelines, that having a client who runs away before the House constitutes an unfair hearing. I'm happy that you've made the communication that we as a House must appeal that decision. And, Mr. Speaker, as already been submitted by the rest of the senators here, it is absurd for them to say that the client who disappeared, whose lawyer could not even tell where he was not given an opportunity to be heard. And therefore, as a House, having made that decision, I believe that we should be allowed to do it. And, Mr. Speaker, granting that adjournment, acting as a quasi-judicial institution, is the discretion of this House. Let's forget for a moment even that we didn't have to comply with the standing orders or the constitutional dictates, which of course we could not. It is the discretion of this House, and therefore we were in our right place and footing to decide as to how to proceed and prosecute the impeachment proceedings that were before this House. And therefore, I fail to understand the basis upon which a grant of damages worth 50 million, which was not asked for by the client again, could be slapped on the House. And despite the fact that we agree in part of the judgment, this particular finding on the fair hearing, Mr. Speaker, cannot stand, and I'm happy that the House will proceed to defend the position that it took. I thank you.
Senator Oburu.
Thank you, Mr. Speaker, sir, for the opportunity. Mr. Speaker, sir, I am equally surprised with the court decision to impose a fine of 50 million shillings on the Senate, when on the other hand, the same court said the Senate was right and the Senate rightly impeached Gachagua according to the Constitution. We followed the Constitution and we impeached him according to the Constitution. And Mr. Speaker, when we were here, all of us were here, when the lawyer himself told us that he did not know where his client was. Now, if he didn't know, then, Mr. Speaker, how could we know as a Senate? How could we know? We did not know also, Mr. Speaker. So we did not know where he was. Now, whatever was brought later on that he was in hospital was an afterthought. And that afterthought, Mr. Speaker, cannot be used to impose a fine on us when we acted constitutionally, and the court has said so. And they have impeached him. Mr. Speaker, it is a contradiction. To me, it is a contradiction, Mr. Speaker. How could you impeach somebody for having breached the Constitution, and therefore the Senate was right, and on the other hand, Mr. Speaker, you impose a big fine. Mr. Speaker, I urge you to appeal. Mr. Speaker, you do the appeal and ensure that the court, our Senate does not pay this 50 million. Mr. Speaker, where do we get 50 million when we are struggling in our steering committee of Parliament? Yeah, we are struggling to get money even to travel locally. So where do we get 50 million? We are poor. If it was with the Assembly, with the National Assembly, perhaps they would be able to pay. But for us, we are not going to pay, and we are also right not to pay, Mr. Speaker. We are going to appeal. We are lawful. We follow the law. And Mr. Speaker, sir, I hope that this kind of judgment will not continue in our country.
Senator Okiya Omtata.
Yes, Mr. Speaker, sir. Thank you for the opportunity to speak to this important issue. First of all, I also thank the Speaker for having moved this motion to have us discuss this issue. And from where I sit, I think it's an issue that does not call for a knee-jerk reaction. It's an issue that calls for reflection and meditation. Because impeachment is a constitutional process. And in the Constitution, Article 150 deals with the removal of the Deputy President. When you look at Article 150, Clause 2, it says the provisions of Articles 144, that's removal on the basis of health, and 145, the impeachment, relating to the removal of the President shall apply with necessary modifications to the removal of the Deputy President. Mr. Speaker, sir, I would like us to take lessons from the judgment instead of condemning it. Because when I look at it, and I'm still convinced, even from the day this impeachment came here, that this House was not prepared for the impeachment of a Deputy President. I say so because we did not have that law that would modify the impeachment of the president to apply to the deputy president. And that, for me, trying somebody without a law, to me, amounts to a violation of their rights. I don't even find a contradiction in the finding of the court that there was a violation of the rights, given the court's own reasoning, which our speaker aptly captures here, where it says that it's like when you get somebody has been executed and you determine that the person was wrongfully executed, that may not restore the person back to life. That's the argument I'm seeing the court say here. And this particular quotation that we find that His Excellency Gachagua's rights were infringed when the Senate declined to allow an adjournment. This violation constitutes both a vindication of his rights and a recognition of the constitutional infirmity in the process that does not undo the impeachment itself, given the finality of Article 145, Clause 7. So, Mr. Speaker, to me, I strongly believe that rules of procedure should benefit an accused person. And given that this gentleman, His Excellency Mr. Gachagua, had requested for an adjournment, this House had the capacity to grant adjournment.
Your time is up, Senator Okiom Tata. Senator Beatrice Ogola.
I thank you, Honorable Speaker. And Honorable Speaker, I rise to support the communication you have just read this afternoon, that this House must appeal. And Honorable Speaker, even with a lay mind, as Senator, my leader, Senator Wambua stated, that is lay to the law, I accept that, but he has eyes and he has ears. And Honorable Speaker, from where I'm seated, I was able to see Senior Counsel Paul Muite, where he was on that day. A number of you maybe had their backs turned to him. And I listened and watched as Senior Counsel representing the former Deputy President say that he did not know where his client was, Honorable Speaker. So, as a Senate, how would we have known where his client was? Honorable Speaker, even in basic absences in schools by pupils and students that are seated here, when they absent themselves from school and say they went to hostels, the administration always expects them to take their books from hospital where they were treated. And I remember in our long history in schools, we would take those exercises books that as evidence that we were in hostel. So if that can be done in schools and in other institutions, why was it difficult for the representative of the former Deputy President to bring evidence to this House that he was unwell, Honorable Speaker? Honorable Speaker, we are paid to sit here by Kenyans. We don't sit here for free. We earn a living from the taxpayers. And even the 50 million that we are expected to use to pay the former Deputy President is taxpayers' money. So Kenyans cannot be taxed twice by paying senators listening to the Deputy President who yes, I accept.
Senator Beatrice, the Speaker has not granted Senator Cherargei the opportunity to inform you. So you proceed to conclude because your time is running out.
Honorable Speaker, what I'm saying...
Hold your information.
Honorable Speaker, what I'm saying is that Kenyans cannot be taxed twice to pay for a criminal who ran away from Parliament. We are senators, we are seated here listening to him, we are paid for that work, and then the same Kenyans' money would be used to pay him the cost of 50 million. I therefore support your communication, and I end by saying that it was right for the Senate to choose the plenary, because then it was open for everybody. Everybody saw Muite here say.
Thank you, Senator Beatrice Ogola. Senator Wakoli.
Asante Mheshimiwa Spika kwa nafasi hii ili kuchangia kuhusiana na mwelekeo ambao tumepewa kuhusiana na mwelekeo wa koti. Mheshimiwa Spika, tuliona hapa mawakili shupavu, mawakili waliobobea katika kutetea washukiwa sugu. Mheshimiwa Spika, katika historia ya Kenya tumeona mshukiwa sugu ambaye stakabadhi zake zilikuwa hapa, na Wakenya tulikuwa tunabukua vitabu tukidua tukishangaa. Mheshimiwa Spika, na ni mara ya kwanza kuona mshukiwa mkuu anatoweka kutoka maeneo ya kesi, na mawakili wake pia wameshangaa. Familia yake haijui mweleze nani, maafisa wa polisi wanaomlinda wamezama. Mheshimiwa Spika, nashangaa sana. Kenya hii ni nchi ya ajabu sana. Mpaka Senate linashtakiwa, tunachochewa, hata baada ya kumngatua tunaambiwa tumlipe pesa kama dawa ya brufen. Yaani augue polepole. Mheshimiwa Spika, ni jambo la kushangaza sana, na inadhihirika wazi kwamba makosa ya huyu shukiwa sugu yalikuwa makosa makubwa sana. Na mimi naomba Wakenya, stakabadhi ziko wazi. Kando na kudai tu kumpa haki, jumba la Senate, Mheshimiwa Spika, tukubali hizi nakala zilizoletwa hapa bunge na madai na ushahidi tuwape Wakenya basi. Tuwape Wakenya, weke kwa magazeti ndio wajue hata tulikuwa na moyo wa utu. Yaani tumzibe uchi, tufunike uchi wake tu, lakini aende. Na wale ambao wako naye katika koti hawajui wanatembea na nani. Yule ni mnyama mwitu ambaye amevaa ngozi ya kondoo. Mheshimiwa Spika, so sisi kama jumba la Senate tutasimama imara. Naomba nimruhusu ndugu yangu
Senator Wakoli, do you want to be informed by the senator from Nandi?
Huyu ni wakili shupavu kupambana na wale sugu. Mheshimiwa Spika.
Very well, Senator Cherargei.
Mr. Speaker, on a point of information, this is a country where a member of parliament abducted themselves. So when the former impeached deputy president ran away, he was borrowing from a classic book of where a sitting member of parliament self-abducted himself. So we were worried with such behaviors, Mr. Speaker. I wish to inform my brother Omwami, Senator Wakoli.
Senator Wakoli, conclude.
Ni bunge la kitaifa ambalo wabunge wanajiteka nyara, na katika maeneo ya utekaji nyara
Give him 30 seconds to conclude.
Mashukiwa wanajiteka nyara, wanaita vyombo vya habari, wanatoa hotuba katika misitu, katika hospitali. Na huyu wetu Mheshimiwa Spika, nashangaa sana. Ati naibu wa rais, namuombea Mheshimiwa Rais afya nzuri, aliumia sana kuongoza nchi na sugu kama huyu. Mheshimiwa Spika, asante sana Mheshimiwa Spika.
Senator Hamida Kibwana.
Bwana Spika, asante kwa kunipa nafasi. Hata mimi nataka kuunga mkono mawasiliano ya Bwana Spika. Kusema kweli tunaheshimu maamuzi ya mahakama, lakini hatukubali ya kuwa former rais deputy president Gachagua hakupewa nafasi na seneti. Kusema kweli tulivumilia sana masaa hapa na tukawa waungwana kuweza kumsikiza, lakini nafikiria aliona atafanya ile inaitwa kipindi, na hiyo kipindi kwa slang wanaita kipindre. Akatufanyia kipindi na ili kutufanya sisi wajinga. Sisi tukakubaliana nayo na mambo yakaisha, lakini leo tunashangaa sisi baada ya kuwa waungwana wavumilivu, haya mambo yanarudi kwetu. Na ile nashangaa Bwana Spika ni kuwa mahakama makuu yenyewe imethibitisha kwa mchakato ule uliofanywa hapa seneti uliidhinishwa na uamuzi wa seneti kumuondoa ofisini na ukawa wa halali. Sasa je, itakuwaje tumetupiwa tena sisi ya kuwa tuweze kumlipa sisi faini hali mtu mwenyewe aliweza kufanya mambo yake? Kwa hivyo mimi naunga mkono hiyo mawasiliano na hiyo faini nitaweza kusema sisi kusema kweli kama seneti hatufai kulipa sisi fine. Manake yeye mwenyewe aliweza kufanya mambo yake, na pia ilikuwa ni aibu kwa mawakili wake. Mawakili wake wenyewe walishangaa, na kama vile bwana Senator Cherargei anasema kama kuna watu hapa waliweza kuweza kumadvise, ilikuwa sio advice nzuri ya yeye kufanya vile alifanya. Kwa hivyo bwana Speaker, mimi naunga mkono mawasiliano ya Speaker ya kuwa hiyo fine si ya kwetu, na ilithibitishwa kuwa sisi chochote kile kiliendelea seneti ilikuwa ni cha halali. Kwa hivyo itakuwaje ya halali alafu sasa ya haramu sisi tulipe sisi hiyo ya haramu ya 50,000? Tunakataa nayo bwana Speaker, na yangu ni kusema tuendelee mbele, tuweze kuappeal, tuweze kukata rufaa ili hayo mambo yaweze kusikizwa vizuri. Asante bwana Speaker.
Senator Hamida, it is 50 million, not 50,000, and that is correct.
Milioni 50 bwana Speaker. Hiyo ni pesa milioni 50. Haiwezekani. Asante bwana Speaker.
Now, honorable senators, that brings us to an end to your comments on the communication that came from the Speaker. And we shall, of course, as directed by that communication, undertake the appropriate steps to make sure that we protect the dignity, sanctity, and the authority of this House by preferring an appeal against that particular decision. Nonetheless, we will resume the order paper for today, and before the communication, we were dealing with, I believe, order number 23. Clerk, you could call for the resumption of a debate on the motion under Standing Order 23.
Order number 23, motion, consideration of the report of the Mediation Committee on the Food and Feed Safety Control Coordination Bill, National Assembly Bills, and number 21 of 2023.
Just hold, Senator Wakoli. The Speaker will guide you shortly. Very well, Senator. I see from my dashboard there are requests to contribute to this motion. I have Senator Mariam, who is not in the chamber, Senator Beatrice Ogola. Okay, you seconded the motion. Very well. Then, honorable senators, there being no other member interested in contributing to this motion, I will call upon the mover to reply. Senator Wakoli, don't tempt the Speaker to take action against use of mobile phones.
Our good esteemed Speaker, thank you for your good heart of forgiveness. I hereby seek your indulgence. Honorable Speaker, pursuant to Standing Order 663, I request that I say that I have heard the concerns of honorable members, and I want to agree that county government are an integral part of ensuring that devolution is meeting the expected outcome to our people. This bill, Honorable Speaker, has space, has room to ensure that the aspirations of the bill are met and that county governments continue to play the role that they are supposed to play. Honorable Speaker, this bill will equally transit to the delegation, the team, the committee that deals with the delegated rules, regulations, and laws, Honorable Speaker. And this is where the rubber meets the road, where the fine-tuning of the various aspects of this bill will be done, and thereafter cascaded down to county governments, the way we had at the national level the Public Service Commission, and which inducted and trained the public service boards at the county level to continue doing the professional work. So I want to encourage members that all is not lost, and this is a new practice in this country where various arms of government are coming together to ensure we meet an expected outcome. And therefore, by that doing, the county governments will be roped in, will be invited, and we will walk the journey with them as Senate to ensure that this bill speaks to the needs, expectations, and the demands of the labor, of the market, international market, and the local market. Our members, honorable members, should know that as the Committee of Agriculture, we have always invited KEFIS, we have invited the Minister of Health to look at the poisonous food, potatoes in Rift Valley, to look at the problem of maize in your county, Honorable Speaker, and it showed very clearly that unless these arms of government in the Ministry of Health, Ministry of Agriculture, Ministry of Trade come together, synergize and polish legislation, we will always limp and run in the dark. And therefore, this bill provides an opportunity for all these arms to come and polish their act and make it practicable to the people, so that the people do not subscribe and get permits everywhere. Because you understand, Honorable Speaker, some of the governors are overtaxing our people. Their so-called kanjos are everywhere collecting money, but the people are not seeing the value. So this institution, once organized properly, will have its replicas at the county level, but they have their mother body that will always guide and ensure that as devolution is strengthened and empowered, the institutions will equally do the same. And therefore, pursuant to Standing Order 63, I request that we're putting the question should be deferred, Honorable Speaker.
Senator Wakoli, it's 66-3. If I heard you right, you said 63. It should be
663.
Standing Order 66-3.
Yes, 66-3.
Very well. Pursuant to the provisions of Standing Order 66-3, putting of the question is hereby deferred to the next sitting. Now, Honorable Senators, before we move to the next order, I will proceed to rearrange for the convenience of the business of the House today. And the rearrangement of the order for today takes us to order number 30. Clerk, call out order number 30.
Order number 30, motion, report of the Standing Committee on Energy on inquiry into the shortage of smart energy meters in Kenya and the potential for their local manufacturing.
Honorable Senators, this is to the Chairperson, Standing Committee on Energy. Senator Kisang, proceed to move the motion.
Thank you, Honorable Speaker. Honorable Speaker, I beg to move that the Senate adopts the report of the Standing Committee on Energy on inquiry into shortage of smart energy meters in Kenya and the potential for the local manufacturing laid on the table of the Senate on Wednesday, 11 June 2025, Honorable Speaker. Honorable Speaker, pursuant to its mandate under Standing Order 228 subsection 3 to investigate, inquire into, and report on all matters relating to the mandate, management, activities, administration, and operations of its assigned ministries and departments, the Standing Committee on Energy at its sitting held in October 2023 resolved to initiate an inquiry into the ongoing shortage of smart energy meters in Kenya and the visibility of promoting local manufacturing of these devices, Honorable Speaker. This decision followed serious concerns raised by the Public Procurement Regulatory Authority, PPRA, regarding alleged irregularities in the award of Kenya shillings 2.9 billion smart meters tender to MS Alay Bari Limited, which had been recommended by the State Department for Energy, raising questions on transparency, competitiveness, and adherence to the Public Procurement and Disposal Act of 2015. Honorable Speaker, the committee also took note of structural challenges in the metering sector, including the absence of clear standards, regulatory frameworks for smart meters, high borrowing costs for potential local manufacturers, and the proliferation of counterfeit meters in the market, all of which undermine reliability, consumer protection, and the country's broader energy sector reform agenda, Honorable Speaker.